Hi everyone, Kristina here with some immigration news that for once is actually good news. And honestly, after months of policy changes, restrictions, delays, and uncertainty, it feels really good to finally bring you a positive update. A few months ago, I made a video discussing the administration's policies affecting nationals from 39 countries. In that video, I explained that USCIS had effectively placed many immigration cases on hold for people from those countries. Applications for asylum, work permits, green cards, and even naturalization were being delayed or frozen simply because of the applicant's country of birth. At the time, many immigration attorneys, advocacy organizations, and affected families were extremely concerned because people who had done everything correctly, followed the immigration laws and procedures, were finding themselves stuck in immigration limbo with no clear answers and, most importantly, no timeline. Well, we now have an important development from federal court. On June 5th, 2026, a federal judge ruled that these USCIS policies were unlawful and ordered them vacated nationwide. The court found that USCIS did not have the authority to create these broad adjudication holds and that the agency could not simply stop processing applications based on an applicant's country of birth or country of origin. The court's decision affects several of the policies that had been causing concern, including the benefits hold that impacted applications for adjustment of status, employment authorization, and naturalization, as well as other country-based restrictions that USCIS had implemented. What does that mean in practice? It means that as of today, USCIS should no longer be relying on these specific policies to place immigration cases on indefinite hold simply because the applicant was born in one of the affected countries. Now, I do want to add one important caution. This does not necessarily mean that every delayed case will now suddenly be approved tomorrow. It also does not mean that the government cannot appeal this decision or seek additional court review. Immigration litigation is often a long process, and we will continue monitoring developments closely. But make no mistake, this is a significant victory. For thousands of immigrants and their families, this ruling reaffirms an important principle. Immigration benefits should be decided based on the law and the facts of the case, not simply based on where someone was born. If you're from one of the affected countries and you have a pending immigration application, this is definitely a development worth paying attention to. As always, we'll continue following these changes and sharing practical updates as soon as they happen. Stay informed and stay safe. Goodbye.